So I'll give brief introduction of Dr. Abhinav Chandrachud. Dr. Abhinav Chandrachud did his LLB in the year 2008 from Govt Law College Mumbai, and thereafter he did his LLM in the year 2009 from Howard Law School, and then he did his Masters of Science of Law in 2012 from Stanford Law School, and then he has done his doctorate in Science of Law in 2014 from Stanford Law University. He joined bar and presently he is practicing in Bombay High Court since July 2014, and prior to that he has worked with foreign firms outside India and in India. So without taking your too much of time, to save the time, I have already forwarded resume with all of you, and you must have gone through this resume, and he has lot of achievements, including writing, number of books to his credits, large number of articles published in newspapers and law journals, and he has been speaking to law students and other law professionals on various subjects of constitutional importance. So welcome Dr. Abhinav Chandrachud, and now I'll hand over to Dr. Abhinav Chandrachud to start the discussion. Yes, sir.
Honorable the Chief Justice of the Jammu and Kashmir High Court, Justice Mittal.
Abhinav, just one moment.
Yes.
Sorry, Rajeev, I'll just say one word. Rajeev, I'll just speak two lines, and then would you also tell the children which law firms Abhinav has worked with? Since we have children who are looking for law careers, it's very important that they know. And all the students who are with us, you must ask Abhinav why he studied so much if he only had to practice, practice law in a court of law, and why he came back from all the big law firms and the big courts that he was practicing with, and start practicing in the courts in India. This will be very pertinent to those of you who are looking to examining the relevance of academics to a legal career. Please do look at talking to the children from this perspective. And all the listeners, please remember the significance of this question, especially in the context of the rights which are required to be balanced. Abhinav will be speaking to you, so I won't elaborate on this. But the huge conflict and conflict which is before courts, which we are constantly dealing with, one man's right of freedom of expression under Article 19, and trying to balance it against the Article 21 rights of the person who is impacted by the exercise of this right. It comes up kind of a conundrum comes before courts when examining several rights. For instance, when you're looking at a prisoner's rights vis-a-vis the rights of a victim, it comes up before us constantly in trying to balance environment against development. And so what you're going to be hearing and discussing today is extremely pertinent, especially in today's context, where the social media seems to have overtaken everything, especially in the context of trials before courts. The impact of the social media and tirades against accused persons before the court has examined the evidence against them, etc. So I will stop here. I'll probably talk to you again at the end after Abhinav has spoken to you and answered your questions. Over to you, Abhinav. No, first, Rajeev, please tell people the law firms that Abhinav has worked with and where.
Yes, ma'am. Yes, ma'am. I'll just mention that between 2009 to 2011, Dr. Abhinav Chandrachud has been with Associate Attorney Gibson, Dunn and Crutcher LLP, Los Angeles, California. And in 2012, he was with Foreign Associate in Fenwick and West LLP, Mountain View, California. So it is after working with these foreign law firms, that he came back to India and has started practicing in Bombay High Court. Yes, over to you, Mr. Abhinav.
Thank you. Honorable the Chief Justice of the Jammu and Kashmir High Court, Justice Mittal, Mr. Rajeev Gupta, the Director of the Jammu and Kashmir State Judicial Academy, the respected judges who are here with us today, students in various law schools in India, ladies and gentlemen. First of all, let me say how grateful I am to Justice Mittal for inviting me to speak to all of you today, and how grateful I am to all of you for attending the talk on a Sunday evening. And Sunday, despite the fact that we're in a lockdown scenario, is still family time. So I'm very grateful to all of you for attending the talk and for listening to me today. The topic of today's discussion, and I will, of course, as Justice Mittal said, be happy to talk a little bit about my own personal experiences abroad and in India, why I went abroad, why I came back to India, and so on. But let me begin by talking to you about the subject itself, which is hate speech in a digitally interconnected India. And I thought, let me begin by giving you a little bit of background about the law, about the constitution in this particular area. You see, prior to the constitution coming into force, there were many laws in India that were used against India's patriots. The provision that dealt with sedition, for example, section 124A of the Indian Penal Code, was used against our leaders like Gandhi and Tilak, who were sentenced to jail for having committed sedition. In fact, it's very interesting. During the pandemic that took place in the late 19th century, the bubonic plague that took place, Tilak had written articles criticizing the government's handling of the plague pandemic. And it was in that atmosphere that the Bombay High Court convicted Tilak and found him guilty of the crime of sedition. And the definition of sedition itself changed during that pandemic. The Indian Constitution, when it was being drafted, followed the Irish model of having the exceptions to freedom of speech and expression included within the text of the Constitution itself. So while Article 19(1)(a), a right that is interestingly only available to the citizens of India, expanded upon what the right to freedom of speech and expression is, Article 19(2) contained the exceptions to freedom of speech and expression. Now, what's very interesting is that when the Constitution was originally drafted, the exceptions to freedom of speech and expression under Article 19(2) were very limited in nature. So, unsurprisingly, sedition was not an exception to freedom of speech and expression. That was somewhat obvious because Gandhi and Tilak, as I told you earlier, had been sentenced to jail for sedition. Public order was not an exception to freedom of speech and expression. Article 19(2) was based largely on a draft prepared by Kanhaiyalal Munshi, a prominent member of the Constituent Assembly, a prominent leader in Bombay, and a famous author of Gujarati. But what happened thereafter was that in 1951, in June 1951, India's provisional parliament, and by provisional parliament I mean that the first elections had not taken place at that point in time. The first elections took place in early 1952. There was no Rajya Sabha at that point in time. The Constituent Assembly was functioning as a unicameral parliament of India. It was that unicameral provisional parliament which amended the constitution for the first time. It was really the Constituent Assembly by another name, by the name of the provisional parliament, which amended the constitution for the first time in June 1951 and inserted certain new exceptions into Article 19(2) of the constitution. And by and large, there were three reasons why the first amendment was enacted in 1951. The first and perhaps the strongest reason was that a judgment had been delivered by the Patna High Court, which was authored by a judge by the name of Justice Sarju Prasad, which sent a chill down the spine of most parliamentarians. In a case concerning Article 19(1)(a) of the Constitution, the freedom of speech and expression, Justice Sarju Prasad concluded his judgment by observing that the new constitutional provision gives India's citizens the freedom to incite murder and other cognizable offences with impunity. Interestingly, Justice Sarju Prasad was elevated as Chief Justice, if I'm not mistaken, of the Rajasthan High Court after delivering this judgment. But this judgment was single-handedly responsible, or almost single-handedly responsible, for the First Amendment. It was extensively cited by Prime Minister Nehru and by other parliamentarians in the debates on the First Amendment to the Constitution. However, there were two other reasons why the Constitution was amended and Article 19(2) was expanded upon by virtue of the First Amendment. The second reason was that the Supreme Court had delivered two judgments that troubled India's political leadership. Those were the judgments in the cases of Romesh Thapar and Brij Bhushan. In those cases, the question was, or let me take a step back and tell you, that the exception to freedom of speech under 19(2) included the security of the state. So in other words, if a person made a speech that tended to undermine the security of the state in India, or that had the tendency to overthrow the state in India, then it could be regulated under Article 19(2). Now, what happened in those cases was, especially the Brij Bhushan case, which was concerned with an RSS publication in Delhi, if I'm not mistaken. In these cases, the question that arose before the Supreme Court was that if a person makes a speech and that speech has the tendency to incite a communal riot, does that riot undermine the security of the state of India, or does it have the tendency to overthrow the state in India? The Supreme Court, by a majority, with only Justice Fazal Ali dissenting, held that if a mere communal riot takes place in one part of India, that communal riot does not undermine the security of India's state. That communal riot does not have the tendency to overthrow India's state. And therefore, even a person who makes a speech that incites a communal riot cannot be punished for that speech. That was essentially the view taken in the Romesh Thapar and Brij Bhushan cases. These two cases resulted in some frantic correspondence between Sardar Vallabhbhai Patel and Prime Minister Nehru, and were also responsible for the enactment of the First Amendment to India's Constitution. The third reason was that there was a gentleman by the name of Shyama Prasad Mukherjee, who was a member of Nehru's cabinet, and in fact a leader of the Hindu Mahasabha, considered one of the founding members of the party that became the Bharatiya Janata Party. Nehru and Prime Minister Liaquat Ali Khan of Pakistan had entered into an agreement at this point in time, where they had agreed that the citizens of their respective countries would not criticize the other country. So in other words, under the Nehru-Liaquat Pact, it was agreed between Prime Minister Nehru and Prime Minister Liaquat Ali Khan that India's citizens could not criticize Pakistan and vice versa. However, Shyama Prasad Mukherjee resigned from Pandit Nehru's cabinet over his disagreements on the Nehru-Liaquat Pact, and then started openly advocating for the forcible reunification of India and Pakistan. So Shyama Prasad Mukherjee spoke of an Akhand Bharat. He argued that India should take military action against Pakistan in order to forcibly reunite the two countries. And these speeches raised objections in the Pakistani administration. And it is with Shyama Prasad Mukherjee's speeches in mind that an exception was inserted into Article 19(2) of the Constitution, that India's citizens cannot undermine India's friendly relations with foreign states. Those words are found in Article 19(2) of the Constitution only because of Mr. Shyama Prasad Mukherjee. Now, what's interesting is that while the First Amendment to India's Constitution restricted freedom of speech and expression, the First Amendment to the American Constitution was responsible for creating freedom of speech and expression in the US. The US tends to be quite an outlier when it comes to freedom of speech and expression. It is perhaps one of the only countries in the world where hate speech is absolutely allowed. It is permissible in the US, for example, to deny the existence of the Holocaust. It is permissible to burn the national flag in the United States. Conservative churchgoers can, at a military funeral, carry out anti-gay protests where the person who is being buried was a gay person. It is permissible in the US for a person to wear a jacket that contains the famous four-letter word beginning with F when it makes a political point. So there's a very famous case in the US. At that point in time, there was something called a draft. All American citizens, men, had to enlist in the army. And at that point in time, somebody wore a jacket in a courthouse in the US, which abused the draft using the four-letter word. And that was found to be permissible free speech. It is permissible in the US for Nazis to hold a march in a neighborhood which has Holocaust survivors. And it is not a crime in the US to call a black person by the highly derogatory name that begins with the letter N for Nagaland. So the US tends to be quite an exception, quite an outlier in the world in allowing all kinds of hate speech. The First Amendment to the US Constitution says that Congress, that is both the houses of the legislative body, the central legislative body, the House of Representatives and the Senate, Congress shall make no law abridging the freedom of speech. Now, this sounds absolute. And in fact, many judgments of our courts say that, well, the right to freedom of speech in the US is absolute, whereas it is not absolute in India. But as Justice Nariman in the recent Shreya Singhal case has opined, the US Constitution tends to be a little deceptive. Even the right to freedom of speech in the US is not absolute. It may have fewer restrictions than there are in India, but the right to freedom of speech and expression even in the US is not absolute. The enactment of the US Constitution, I thought maybe let me talk to you also a little bit about this, is a fascinating subject. The US Constitution was drafted by a body called the Philadelphia Convention, which met not to draft the Constitution, but only to amend the previous Constitution, what was referred to as the Articles of Confederation among the 13 colonies. The proceedings of the Philadelphia Convention, unlike the proceedings of our own Constituent Assembly, were held in secret. The proceedings were never published. There was one man by the name of James Madison, who was a member of the Philadelphia Convention, later President of the US, who took down copious notes of what transpired in the Philadelphia Convention. And that is really the only and the most reliable record, if not the only one, the most reliable record of what transpired in the Philadelphia Convention at the time of the drafting of the US Constitution. The US Constitution required ratification by the colonies. There were 13 colonies, and they had to all agree to adopt the US Constitution, which was not so in India. Our Constitution was drafted by a Constituent Assembly whose members had been indirectly elected by provincial legislatures, whose own members had been elected on the basis of separate electorates and not on the basis of universal adult franchise. So in other words, only those who had property or educational qualifications had the right to vote in the elections for provincial legislatures. And it was the members of those provincial legislatures who voted and elected the members of the Constituent Assembly of India. That constitution did not have to be ratified by the people of India, unlike the US Constitution. Now, what's very interesting is that the US Constitution contains, of course, many amendments that run into around 27 or 28 amendments. But the first 10 amendments to the US Constitution are often referred to as the Bill of Rights. Now, these amendments were enacted and available only against the federal government. So, for example, the First Amendment, which I told you about, freedom of speech and expression, was only a right available against the federal government, not the state governments. Because these amendments were enacted as a result of a debate which took place between two factions in the US at that time, the Federalists and the Anti-Federalists. The Federalists, like James Madison, were of the opinion that there should be one national federal government in the US, and they were in favor of the US Constitution. The Anti-Federalists, on the other hand, were those who believed that the colonies should be sovereign and that the central government should only be something like the European Union, a very loose confederation of states. The most famous anti-federalist was a man by the name of Patrick Henry in Virginia, who was famous for having made the statement at the time of the American Revolution, "Give me liberty or give me death." It was because of this debate which took place between the Federalists and the Anti-Federalists that the US Congress enacted the first 10 amendments to the Constitution to essentially guard against abuse of power by the federal government. It was much later, after the Civil War in the middle of the 19th century, the American Civil War, that certain amendments were enacted to the US Constitution, namely the 13th and 14th Amendments, that were referred to as the Reconstruction Amendments, by virtue of which fundamental rights became available also against state governments. So, for example, the right to equality under the Fifth Amendment was initially only available against the federal government. The state governments were absolutely free to mistreat African American slaves. But after the 14th Amendment, the 13th Amendment abolished slavery in the US. And the 14th Amendment said that even the states must be equal in their treatment of American citizens. And then, of course, I won't talk about this in great detail, but only to briefly tell you, the US Supreme Court invented this doctrine called substantive due process, as a result of which all the rights that are available against the federal government through the prism of the 14th Amendment are made available against the states as well. So today, even though there is no specific provision in the American Constitution that gives American citizens the right to freedom of speech and expression as against the state governments, the US Supreme Court has held that by virtue of the 14th Amendment, the right to freedom of speech is also available against the state governments. I'll only end this discussion on the enactment of the US Constitution by telling you about what I'm sure many of you have already heard about, the Federalist Papers. The Federalist Papers were drafted by three gentlemen, Alexander Hamilton, James Madison, who I've already told you about, and John Jay, who became the first Chief Justice of the US Supreme Court. Alexander Hamilton has recently become quite a superstar in the US. A brilliant biography was written on him by a gentleman by the name of Ron Chernow. And that book was then converted into a famous Broadway play that is now available on Disney Hotstar. And for any of you who are interested in American Revolutionary era history, despite the poetic licenses that have been taken by the playwright, I would thoroughly recommend that play because it brings all the characters of the Revolutionary era to life. Now, the Federalist Papers were propaganda pieces that were written by the Federalist faction in the US in order to encourage people in the states, in the colonies, to ratify the US Constitution. At that time, there was an unwritten rule that gentlemen, and mind you, all these founding fathers of the US were aristocrats. They were landholding, many of them were slaveholding people. The unwritten rule was that gentlemen did not write articles in newspapers. It was unseemly. It was not the done thing for gentlemen to write in newspapers and to get involved with the nitty-gritty affairs of politics. And so the Federalist Papers were written pseudonymously. The three writers adopted pseudonyms, typically the names of Greek or Roman philosophers. And that's really what we now know as the Federalist Papers. The most famous Federalist paper that is quoted in India is the paper written by Alexander Hamilton that the judiciary is the least dangerous branch because it has neither the power of the purse nor the power of the sword. But mind you, Alexander Hamilton wrote that perhaps in some form as an exaggeration, because Alexander Hamilton was trying to convince American citizens that, look, we are not trying to re-establish a monarchy. We have, through a hard-fought war with the United Kingdom, won independence and won a republican form of government. We are not going to go back into a monarchy. The question was that if you're going to give judges life tenure, then is this not like a monarchy? And so Alexander Hamilton was trying to placate people and tell them that, look, the judiciary is going to be powerless as it is because it has no power. And therefore, please ratify the American Constitution. There is no threat of a monarchy in the United States. Now, coming back to the topic at hand, freedom of speech and expression. In the United States, there are broadly two approaches, or there are two viewpoints that I think lie at the heart of every judgment in the US on freedom of speech. The first viewpoint was a viewpoint advocated by the famous judge, Justice Oliver Wendell Holmes, in the case of United States versus Schenck, where Justice Holmes said that the most stringent protection of freedom of speech and expression will not protect a man in falsely shouting fire in a crowded theatre. What Justice Holmes meant by that was that a person who falsely shouts fire in a crowded theatre, in other words, a person who says fire, fire in a theatre despite knowing that there is no fire, that person cannot be argued with. That person cannot be reasoned with. There is no scope for reasoned debate. Because by that person's very utterance of those words, fire, fire, that person has immediately induced a panic. It is impossible to argue with the man who falsely shouts fire in a crowded theatre. And therefore, only that kind of speech that incites imminently an offense, that kind of speech that cannot be reasoned with, that cannot be debated with, it is only that kind of speech that ought to be prohibited by the law. All other kinds of speech, no matter how harsh, should be permitted because you can reason with that speech, you can debate with that speech, and in that impassioned debate, the truth can possibly emerge. The second viewpoint, which I think animates the judgments of the US Supreme Court when it comes to freedom of speech and expression, was the viewpoint expressed by Justice Brandeis in the case of Whitney versus California, where Justice Brandeis said famously that the remedy for bad speech is more speech, not enforced silence. So according to Justice Brandeis, if somebody says something that according to you is false, the answer to that is that somebody should contradict that person. But that person should not be banned from speaking. That person should not be put behind bars for merely uttering a falsehood, because that falsehood can be contradicted by truth in the marketplace of ideas. So these are broadly the two ideas that animate the US Supreme Court's judgments and the US Constitution when it comes to freedom of speech and expression. Now, coming to India, the law of freedom of speech and expression in India, by and large, is criminal law. There are many sections of the Indian Penal Code that fall within the reasonable restrictions under Article 19(2). Notably, and I'll discuss some of these in some detail, Section 153A, promoting enmity and hatred between different groups, 295A, that is abusing the founder or a god or religious personality, 505(2), which is really the mirror image of 153A, only publication is necessary, 504, provoking a breach of the peace, a non-cognizable offense, 500, defamation, 292, obscenity, and obscenity largely means sexual obscenity, not abusive language, 124A, sedition. Then there are other statutes, 66A, I'm sure many of you may have encountered, of the Information Technology Act, which was struck down, Section 31R and S of the Atrocities Act, which makes it a criminal offense to abuse a person by caste name in a place within public view. And the list goes on, but these are primarily the offenses that you might encounter in your day-to-day practice. Now, I thought, let me take a step back from the theory and give some of you, as many of you are young law students about to embark on a career in the law across the country, I thought let me give you some practical tips, things that I have adopted, practices that I have adopted in my own practice when I get a case concerning freedom of speech and expression, or generally a criminal case. The first question is the case a case concerning bail, or is it a quashing case? Now, a client might come to you and you might decide that, look, let us file a petition under section 482 of the Criminal Procedure Code to quash the FIR itself, because according to you, no case is made out. If the case comes to you in the form of a quashing case, you must read the sections which have been invoked in the FIR, and in particular, focus on the cognizable offenses. You need not focus on the non-cognizable ones, because if you are able to convince the court that no cognizable offense is made out, the court is duty-bound to quash the FIR, despite the fact that a non-cognizable offense may have been made out. Because a non-cognizable offense can only be really invoked in a complaint, not in an FIR. The police have no power to investigate the case or arrest the accused if the offense is merely non-cognizable. So focus in a quashing case on the cognizable offenses. Similarly, if your client comes to you and says that I want you to represent me, or typically if it's a regular bail case, then the relative will come to you. But if it's an anticipatory bail case under 438, in a state where 438 has not been deleted, then you must focus on the offenses that are non-bailable. The offenses that are bailable you need not be concerned with, because bail is a matter of right. This is often a misconception. What is the meaning of a bailable and a non-bailable offense? When I, as a young law student, read these words for the first time, I thought non-bailable means that you can't get bail, whereas bailable means you can get bail. That's incorrect. A bailable offense is an offense where an accused person is entitled to be released on bail as a matter of right. A non-bailable offense is a case where a magistrate at the magistrate's discretion may release the accused on bail. You have to request bail, and bail may or may not be granted. It's not a right in that sense. So in a bail case, focus on the offenses that are non-bailable offenses. A practical tip that I'd like to share with all of you, and this is something that I frankly learned the hard way only a few weeks ago in a case that I was arguing. Be very careful when you read these bare acts, because many of these bare acts make mistakes. In fact, a bare act that I rely on very heavily, Professionals, which by and large I found to be an excellent bare act. I had a case under section 324 of the IPC. Of course, doesn't concern freedom of speech and expression, but I think this is an important lesson that I should share with all of you. Section 324 of the IPC, according to the Professionals Bare Act, is a non-bailable offense. So I thought that it's a non-bailable offense. And the judge asked me, is it bailable or non-bailable? I said it's non-bailable. Then my attorney prodded me and said, no, I believe it's bailable. I looked at the Bare Act very carefully. I even opened up the Code of Criminal Procedure. I found that the section had been amended in the year 2005, and the word bailable had been replaced with the words non-bailable. So I assumed that the offense is non-bailable. However, after some further research, I realized that the statute that had amended the Code of Criminal Procedure by making the section non-bailable, a statute enacted in the year 2005, has not yet been brought into force. So though the Professional Bare Act says that section 324 of the IPC is a non-bailable offense, it is in fact still a bailable offense. So imagine the kind of difference that would have made to my client, that did make to my client, the fact that the section itself was a bailable offense, where my client was therefore entitled to be released as a matter of right on bail. So be very careful when you're reading these Bare Acts. Look at the footnotes and investigate, research the footnotes. Now, what is a quashing case? I think let me take a step back and talk to you a little bit about what is quashing. You see, there are two judgments that have been delivered by the Supreme Court that I believe are mirror images of each other. The first one is the case of Lalita Kumari, and the second is the case of Bhajan Lal. And these are really mirror images, and I'll tell you what they've said. In Lalita Kumari's case, the Supreme Court has said that if a person goes to a police station and gives the police officer information that reveals the commission of a cognizable offense, then the police officer has no option but to register an FIR, Section 154 of the Code of Criminal Procedure. So the law is that if I go to the police and tell them that somebody abused me, that could be an offense under 504, non-cognizable offense. The police are not duty bound. In fact, they cannot register an FIR since it's only a non-cognizable offense. However, if I go to a police station and tell the police that somebody has encouraged the listeners to take up arms against the Indian government, that would be sedition under Section 124A, cognizable offense, and therefore the police are duty bound to register an FIR because I have given the police information that reveals the commission of a cognizable offense. It is not for the police at that stage to investigate whether what I am saying is correct or not. Once I tell the police something that reveals the commission of a cognizable offense, the police have to register an FIR. This is Lalita Kumari's case. Now, what the Supreme Court in Bhajan Lal's case has held is the mirror image of Lalita Kumari. In Bhajan Lal's case, the Supreme Court says under Section 482, when a case comes for quashing an FIR, the court must read the FIR and accept that everything contained in the FIR is correct. Despite that, if no cognizable offense is made out, then the FIR must be quashed. In other words, like Lalita Kumari's case, since the FIR itself does not reveal the commission of a cognizable offense, the police could not have registered an FIR at its very inception, since no cognizable offense is made out, and therefore the FIR is to be quashed. So the jurisdiction of the high courts, and mind you, the inherent power of the criminal court under Section 482 is only a power that belongs to the high courts and superior courts, not to the subordinate courts, unlike Section 151 of the Code of Civil Procedure, which gives every civil court in the country an inherent power. Inherent powers only belong to the high courts and the Supreme Court under Section 482. So that's the interesting thing about Bhajan Lal's case. Now, if a case comes to you, which is a bail case, the court may ask you a few questions, and these are things that you should perhaps focus on. You may ask yourself, has the offense been made out? Though this is strictly speaking and formally not the test. The formal test is a prima facie case made out. But invariably, when you're arguing a bail case, you will find yourself trying to convince the judge that, in fact, there is no case made out against my client. Apart from that, there are other questions that the court may be concerned with in a bail case. For example, is the investigation complete? If the investigation is complete, there's no need to keep the accused in custody, unless there are some other factors that I'll come to. Is custodial interrogation necessary? What are the criminal antecedents of the accused? If the accused has many criminal antecedents, there's a danger that he might commit the same offense again. What is the gravity of the offense? Is it a very serious offense? What is the risk that the accused might flee from justice if he's released on bail? And in fact, that you can point out by saying that the accused lives here, the accused has a job here and has lived here for many years. That takes away that risk. What is the likelihood that the accused will tamper with the evidence or try to influence the witnesses? Now, what's very interesting is that in India, we use the term preventive detention only in the context of habeas corpus cases. That is, when a person is arrested in anticipation that he or she may commit a crime in the future, that is considered in India to be preventive detention. But actually arresting a person and putting that person behind bars on the assumption that that person may have committed a crime already, in other words, any bail case, is also in the nature of preventive detention. Because after all, there is a presumption of innocence. There's a presumption in our country and in the common law generally. In fact, going back to William Blackstone's commentaries on the laws of England, the presumption is that it's better that 10 guilty persons escape than that one innocent suffer. There's a presumption of innocence until proof of guilt. So to put a person behind bars on the assumption that that person may have committed a crime already is also a form of preventive detention. By and large, let me also tell you that because the law of freedom of speech in our country is criminal law, the process itself tends to be the punishment. So let's assume that you make a speech today that does not fall foul of the test of hate speech under 153A or sedition under 124A and so on. Let's assume that the police register an FIR against you. That will put the fear of God into you if you're an honest, peace-loving person. It's very rare for a criminal case to be filed against a person. Knowing that there's a criminal case against you may put the fear of God into you. You'll have to engage an advocate. You'll have to pay money out of your own pocket to engage an advocate in order to obtain anticipatory bail under 438 or regular bail if you get arrested. You may have to quash the FIR under 482. You may have to approach the High Court. You may have to cooperate with the police in their investigation and subject yourself to investigation. In a case under 153A, if the hate speech occurred on Twitter or on social media, you may have to give up your phone and your laptop to the police for a long time. So all these things, even though you might actually be found not guilty, even though you may be acquitted by a criminal court, the process of entangling yourself in the criminal law mechanism of the country, in the criminal law system of the country itself is punishment. Now, a court might tell you, in fact, this is now speaking from personal experience, if you appear in a case under section 482 of the Code of Criminal Procedure for quashing of an FIR, you are entitled to ask for interim protection, even though your client may not have approached a court for bail, whether anticipatory or regular. You are entitled to ask the High Court under 482 for interim protection. And I'll come to a few cases that you might want to cite in a case like this. But the bench might invite your attention to a famous judgment delivered by the Supreme Court in 2014 called the case of Arnesh Kumar versus the state of Bihar, delivered in 2014, reported at 14.8 SCC 273. Now, in this case, the Supreme Court said that where the offense is 7 years or less, the powers of a police officer to arrest the accused are limited. And so a High Court may tell you, since your case concerns freedom of speech and expression, the offenses under 153A and so on are typically under 7 years. So the High Court might tell you in a quashing case that, look, why do you want interim protection? Your as it is covered by the judgment of the Supreme Court in Arnesh Kumar's case. But honestly, if you look at Arnesh Kumar's case, in particular, I'm referring to the SCC report, para 7.1, 7.2. Very vast powers have been given to the police to arrest a person accused of an offense that is punishable with 7 years or less in prison. So the Supreme Court says, relying on section 41(1)(b) of the Code of Criminal Procedure, that a police officer cannot arrest an accused merely because he believes that that person has committed the crime, but must also be satisfied that arresting the accused is necessary for a proper investigation of the case. Now, that basically means that in any case where the police officer feels that in order to investigate the case correctly, he needs custodial interrogation, he's free to arrest the accused so long as he records his reasons in writing. So this is quite a vast power that is given to police officers. So be careful of this trap of Arnesh Kumar, where a court might tell you that you don't require interim protection because of Arnesh Kumar's case. Please invite the court's attention to para 7.1 of the judgment and say that the police, despite this judgment, actually have very vast powers to arrest a person who is accused of an offense punishable with fewer than 7 years in prison. Then we come to a thorny issue, which is that if your client has not approached a court for bail under 438 anticipatory bail or regular bail under 439, can a High Court under section 482 in a case concerning quashing of an FIR or charge sheet give bail or interim protection, not bail but interim protection, no coercive steps order as we say, in a 482 matter? And the case that is often cited against this proposition is a very highly misunderstood case, and that is the case of State of Telangana versus Habib Abdullah Jilani, decided in 2017 by the Supreme Court. There, the Supreme Court laid down a very different proposition. What the High Court had done was that a case had been filed before the High Court under section 482 of the Code of Criminal Procedure for quashing of an FIR or charge sheet as the case may be. The High Court found that there was no merit in the petition. So it decided that it was going to dismiss the petition under 482 because in fact a cognizable offense had been disclosed in the FIR. However, the High Court, while dismissing the 482 petition, decided to pass an order of anticipatory bail under section 438 of the Code of Criminal Procedure. It was this practice that the Supreme Court deprecated in the state of Telangana judgment. The Supreme Court said that if a High Court finds no merit in a petition under Section 482, it cannot convert that petition into a petition for bail, or it cannot, whilst dismissing the petition, release the accused on anticipatory bail. However, the court said in para 23, I'm once again referring to the SCC volume, that where a case for quashing is made out, interim protection can certainly be granted, especially in those states where Section 438 of the Criminal Procedure Code is deleted, as it is, I believe, in the state of Uttar Pradesh. And judicial restraint is generally the order of the day in other cases. So similar cases might be cited against you. The case of Panful Nisa versus Muhammad Miraj Ali, decided in 2008, where once again the Supreme Court noted that the High Court decided not to interfere under Section 482 of the Code of Criminal Procedure, but nonetheless granted bail under Section 438. It is only this practice that is deprecated. So in short, in a 482 case, if you are able to make out a prima facie case, you can request the High Court for interim protection and say that state of Telangana and that line of authorities does not apply to your case, because yours is a case where you can make out a prima facie case. It is not a case where the High Court is dismissing the petition but converting the petition into one for bail. And then before I come into, I thought I'll also talk to you a little bit about a few of the cases that I find fascinating on this subject. But before I launch into a discussion on each of the individual cases that I wanted to talk to you about today, let me just tell you that I find criminal law generally to be quite a fascinating area for those of you who might be interested. Unlike civil law, criminal law is extremely precise. In the vast majority of cases, there are only 3 statutes that you need to concern yourselves with: the Indian Penal Code, the Criminal Procedure Code, and the Evidence Act. There are, of course, many other criminal statutes, but in many cases, you'll only be concerned with these 3 statutes. Now compare this with something like a suit for partition by metes and bounds. Where does the law of partition by metes and bounds in a Hindu undivided family begin and where does it end? The law has been laid down in several judgments over the past 150 years. So it's extremely difficult to pin down and to define with precision what the law is in cases in civil law, in many cases in the civil law. Whereas in criminal law, you know what the section says. You know what the ingredients of the section are by plainly reading them. The Supreme Court in many cases has analyzed what the ingredients of the section are. And so it's extremely precise. During the lockdown especially, I found that practicing criminal law has been far more satisfactory than practicing civil law. And I'll give you a few reasons why. First and foremost, I found that at the ad interim stage in civil cases, the arguments tend to be not about the substance of the dispute, not about the merits of the case, but about things like equity, delay, prejudice. I'll give you an example. I appeared in a case, now this is prior to the lockdown, which was at the ad interim stage. I was appearing on behalf of the plaintiff. Now, ad interim incidentally means before the defendant has filed a reply. So the court only had before it my plaint and my interim application. No reply had been filed by the defendant as yet. The case had come up for the first time for ad interim relief before the court. All that the defendant said, and I had such a strong case on the merits of the matter, all that the defendant said was, kindly see paragraph 35 or whatever the paragraph was of the plaint. The plaintiff has said that the cause of action arose in February. This case has been filed in August. There is no urgency. Kindly allow me to file a reply. And on the basis of the fact that my client had committed a delay in filing the suit, a delay of around 6 months, ad interim relief was refused. And the case, because of the fact that there are so many thousands of cases pending in our courts, the case never came up again. And effectively that ad interim order, or the absence of that ad interim order, has now become final relief. Now contrast that with a case of bail. In a bail matter, you'll appear before the court. It may get adjourned once or twice, no problem. But the court will be concerned with the merits of the matter. The court will be concerned with knowing whether the ingredients of the offense are made out, whether all these other factors also exist, antecedents and so on, as I told you earlier. In many cases, in bail cases, especially I practice only at the Bombay High Court. So I can tell you that judges of the Bombay High Court who hear bail cases often sit much beyond 5 o'clock, which is the official time for the court to rise, simply because a person's personal liberty is at stake. So judges at the Bombay High Court hear bail cases going up to 7 p.m., 7:30 p.m., 8 p.m. So your case is likely to reach, unlike in the civil law, where your case may not reach despite being listed on board. And of course, and how can I forget this? In criminal cases, knowledge of the local language is essential. So that's an inherent entry barrier, for good or for bad. If you don't know the local language, in Mumbai it is Marathi. If you're not able to speak Marathi in Mumbai, if you're not able to read Marathi, you won't be able to read the FIR. You won't be able to read a charge sheet. In your junior days, your client may not have the wherewithal to translate the FIR and charge sheet for you. And in any event, the judge may want to read the original Marathi text. And so there's an inherent entry barrier against people coming into that field of law. So for good or for bad, if you know the local language, if you're interested in criminal law, it's a very, very interesting field. And I would certainly invite you to consider this field more carefully. Okay, so let me now, in the time that I have left, dive into a discussion of some cases on section 153A in particular that I found to be quite interesting in my research. 153A of the IPC was a section inserted in the year 1898, and it was subsequently substituted in the year 1969. Hate speech was originally considered to be a species of sedition, but now it finds its own place separately in the statute book, that is the Indian Penal Code. What section 153A does is that it makes promoting disharmony or feelings of enmity, hatred, or ill will between different religions, racial, language, or regional groups, castes, or communities a crime on grounds of religion, race, place of birth, residence, language, caste, or community, or any other ground whatsoever. And 153A, unlike 505(2) of the IPC, can be committed even by a person making a speech that is not published. So unlike 505(2) of the IPC, where a publication is necessary, even a person who simply makes a speech can be convicted of an offense under 153A if the ingredients of the offense are made out. Now, perhaps the most interesting case decided on section 153A was decided by the Supreme Court in the year 1997. And that was the case of Bilal Ahmad Kalu versus the state of Andhra Pradesh. This was a case decided by two learned judges of the Supreme Court, with Justice Thomas writing the judgment for the court. Incidentally, Justice Thomas wrote a beautiful autobiography after retiring from office called The Honeybees of Solomon, which I would encourage you to read for those of you who might be interested. The facts of this case were quite interesting. The appellant, Bilal Ahmad Kalu, was a young man from the state of Kashmir. The case against him was that he was part of a militant outfit and that he had gone to Hyderabad in order to spread communal hatred among young Muslims there. It was said, or the police case was, the prosecution's case was, that Bilal Ahmad Kalu told Muslims in Hyderabad that Muslims in Kashmir were being subjected to atrocities by the Indian Army. The Supreme Court found that it was established beyond doubt that the appellant was spreading the news that members of the Indian Army were indulging in the commission of atrocities against Kashmiri Muslims. The only question was whether these acts amounted to an offense under sections 153A and 505(2) of the Indian Penal Code. The court said that intention or mens rea was an essential ingredient under sections 153A and 505(2) of the IPC. In other words, the question always is, does the speaker intend or did the speaker intend to promote disharmony and hatred between different groups? The Supreme Court noticed that the main distinction between 153A and 505(2), as I told you earlier, was publication. So if the words are published, then 505(2) comes into play. But if they are not published, 153A might still come into play. And then the Supreme Court said something quite interesting. It said that in order for an offense under section 153A to be made out, it is necessary that at least two groups should be involved. So merely inciting the feeling of one community, said the Supreme Court, or one group, without any reference to any other community or group, cannot attract either of the two sections, whether 153A or 505(2). So because Bilal Ahmad Kalu was only instigating the feelings of one community, but not promoting hatred against any other community, he was speaking against the Indian army, not against any religious group. For that reason, the Supreme Court found that no case was made out under 153A and 505(2). Of course, the appellant was convicted under the Arms Act, but as far as these sections were concerned, the Supreme Court says that that case was not made out. Now, this is a very interesting case, but I advise you to be, or there is a note of caution that I'd like to sound when you're citing this judgment. Bear in mind that if you cite this judgment in a case under section 482 of the Criminal Procedure Code, in other words, if you are arguing a quashing case, if you cite this judgment, the chances are that the court will say that this judgment is distinguishable because this was a case which came to the Supreme Court after the evidence had been led and after the trial had been concluded. So one way around this is that there are many High Court judgments depending on which High Court you're appearing in. I appear in the Bombay High Court, so what I tend to do is I look at the Bombay High Court judgment in a 482 matter which cited Bilal Ahmad Kalu's case, and I cite that judgment. So I argue in a quashing case that please see, the Bombay High Court has in fact relied on Bilal Ahmad Kalu's case and applied that principle even to a quashing matter under section 482. So that takes away the argument that this judgment is distinguishable on the grounds that this judgment was decided only after, or this case was decided only after a full trial had concluded. Now, the second case that I find very interesting in this area, and I'm of course not going chronologically, this is a case that was prior in point in time to the Bilal Ahmad Kalu case. But that was the case of Balwan Singh versus the state of Punjab, decided in March 1995 by a bench of two learned judges of the Supreme Court. Now, interestingly, if you read this judgment, you'll realize one thing, which is that the judgment does not have any author. The judgment has been written for the court and there is only an order. There is no author of the judgment. So when there was or let me put it this way, when the Ayodhya judgment was delivered, I found it very interesting that some people criticized the judgment for not having an author. And there were some scholars who said that, well, this is unprecedented in our history. But actually, if you do legal research, you'll realize that there are many such judgments. And not merely orders, I'm talking about judgments delivered by the Supreme Court, where there is no author, where the judgment has been written for the court. And a prime example is the judgment in Balwan Singh's case. Now, the facts of this case were very interesting. Balwan Singh and Bhupinder Singh were senior clerks in the Punjab School Education Board. Now, on the day on which Prime Minister Indira Gandhi was assassinated, that is 31st October 1984, they went outside a cinema called Neelam Cinema and they raised slogans. It was a crowded place. And their slogans were Khalistan Zindabad and so on. They were anti-India slogans. The question was whether this was sedition, which I'm not for the moment concerned with in this talk, and hate speech under 153A, whether hate speech was made out or not. The Supreme Court interestingly noted that the facts of this case showed that there was no actual disturbance which took place, and therefore there was no intent to cause disorder, said the Supreme Court. So because no actual disturbance had taken place, the Supreme Court said that the appellants did not intend to cause any disorder. The Supreme Court also said, and I quote, "It appears to us that the raising of slogans only a couple of times by the two lonesome appellants, which neither evoked any response nor any reaction from anyone in the public, can neither attract the provisions of Section 124A or of Section 153A IPC. Some more overt act was required. The police officials exhibited lack of maturity," said the Supreme Court, end quote. The Supreme Court called the police oversensitive in a matter like this. So the principle is that the mere raising of some casual slogans which did not evoke any response, cannot be considered to be hate speech cannot be considered to be sedition, whether under 153A or 124A of the IPC respectively. Now, what's very interesting though is, I told you about the process being the punishment in criminal law. Now, bear in mind, the offense took place on the date on which Indira Gandhi was assassinated in October 1984. This case was decided by the Supreme Court in the year 1995. That is 15 years later. 11 years later, I'm sorry. Now, what I invite all of you to do is ask yourselves, were Balwan Singh and Bhupinder Singh punished or not? They were, of course, acquitted by the Supreme Court. They were found to be not guilty. But in that process of being involved in the criminal justice system for 11 years, engaging lawyers, paying lawyers, repeatedly making visits to the court, being under the fear, having the sword of Damocles hanging over your head that you might be imprisoned, you might be convicted, was that by itself not the punishment? Did the state not achieve its objectives, despite the fact that these two individuals were acquitted? So that's something that is referred to in the criminal law and in the law of freedom of speech as the chilling effect of the law. That despite the fact that the law is very clear that no hate speech can be made out in cases like this, if the state decides to prosecute you, it may take a long time for you to acquit yourself. And therefore, you might actually decide to self-censor yourself in order to ensure that nobody prosecutes you, even though that prosecution may be absolutely lacking in merit. The next case that I thought I would discuss is the case of Ramesh versus the Union of India, decided in the year 1988 by a bench of two learned judges of the Supreme Court, with Justice Sabyasachi Mukherjee as he then was deciding or writing the judgment for the court. Now, this was a case where the petitioner had filed a petition under Article 32 of the Constitution directly before the Supreme Court. The petitioner was an advocate practicing in the Bombay High Court. He approached the Supreme Court in order to restrain Doordarshan. By the way, back then, Doordarshan really was the only option if you wanted to watch television. And it was all the prominent television shows used to be shown on Doordarshan at that point in time. So the petitioner wanted to restrain Doordarshan from showing a television film or a serial called Tamas. Now, this was a serial that showed tensions between Hindus and Muslims and Sikhs and Muslims in pre-partition India, pre-independence Lahore. And the Supreme Court really was asking itself whether hate speech is made out, whether there's a case for censoring this serial Tamas. And the Supreme Court cited with approval the words of Justice Vivian Bose. Justice Vivian Bose was an Anglo-Indian. He was a judge of the Supreme Court of India in the 1950s. In fact, Justice Hidayatullah, in his autobiography, wrote about his interactions with Justice Vivian Bose when he became a young judge of the Supreme Court. And I would encourage you to read Justice Hidayatullah's autobiography, My Own Boswell, for a fascinating introduction for the life of an early Supreme Court judge. And that interaction between Justice Vivian Bose and Hidayatullah is a really memorable one when you read that autobiography. Justice Vivian Bose, when he was in the Nagpur High Court, wrote, and those words were cited with approval in the Ramesh case by the Supreme Court, that the effect of the words must be judged from the standards of reasonable, strong-minded, firm and courageous men, and today I'm sure he would add the word women, and not those of weak and vacillating minds, nor those who scent danger in every hostile point of view. This, in our opinion, said Justice Bose, is the correct approach in judging the effect of exhibition of a film or of reading a book. So the question that the Supreme Court asks itself in cases like these is not, will oversensitive people be offended by the speech in question? Will an oversensitive person take offense? No, that is not the test. The test is that by reading this book or by watching this film, will a reasonable, strong-minded, firm and courageous person be offended? And will that person be incited to committing an offense or be incited into committing or participating in a communal riot? That's the test. Now, what's very interesting here is that the Supreme Court in Ramesh's case cited with approval the words of the High Court of Bombay in para 20, I'm referring to the SCC version, where the High Court had said that even illiterates are not devoid of common sense. and therefore the judges had viewed the film from an average, healthy, and common sense point of view. Now, the reason I found this judgment to be quite unique and quite striking is that up until that point in time, the belief was that if the speech is targeted to illiterate people, or if the speech is targeted to an audience of those who speak the local language, then there's a greater likelihood that those people will erupt into violence, and therefore there should be a lower degree of deference to speeches that are catered or that are targeted towards illiterate people or those who speak the local language. The Supreme Court seems to move away from that point of view in the Ramesh judgment when it says that, look, even if a speech is directed at and has as its audience illiterate people, even illiterate people are not fools, even they are not devoid of common sense. And so any speech or any film or book must be judged from the point of view of an average, healthy, and common sense person. And that is the yardstick. So, in other words, the heckler's veto, this is in free speech law referred to as the heckler's veto, has been resoundingly rejected by the Supreme Court in the Ramesh judgment. Let me only briefly tell you what the heckler's veto is. Imagine that you're a stand-up comedian, that you're telling jokes in an audience to an audience. Let's assume that one person in that audience is offended by your joke. He or she stands up and stops you and prevents you from cracking any more jokes. That person is a heckler. Because that person is offended, no one else in the audience is able to hear any more jokes that you're cracking. That is called the heckler's veto. And the Supreme Court says that no, an oversensitive person is not entitled to decide what others, what common sense people, what reasonable people can and can't hear. The test must always be that will a reasonable person take offense? Will a reasonable person be incited into the commission of an offense as a result of this speech? I know that I'm running out of time. I believe, about 10 minutes, so Mr. Gupta may correct me. But I thought let me talk about just a few more cases, maybe one or two more cases, and then maybe I can open it up to discussion. But one case that I thought I must discuss is the case of Manzar Sayyad Khan versus the state of Maharashtra, decided in April 2007 by a bench of 3 learned judges of the Supreme Court. This case had in fact come from the Bombay High Court, where a quashing petition had been filed before the Bombay High Court under Section 482. Initially, the Bombay High Court had granted an interim order of protection against the petitioner, or in favor of the petitioner. But thereafter, that interim order was vacated, and the crime branch of the police were directed to complete the investigation on the basis of the FIR which had been registered in Pune. The appellant, Manzar Sayyad Khan, was the constituted attorney of the famous publication house, Oxford University Press. OUP, as it is known, had published a book called Shivaji, Hindu King in Islamic India, which had been written by a professor, Professor James Lane, who was a professor of religious studies at Macalester College in the US. The book had been released in the year 2003. OUP withdrew all the copies of that book from circulation because, upon reading that book, an angry and incensed mob in Pune blackened the face of a scholar who had been merely thanked in the acknowledgements. So the author, James Lane, had merely thanked a scholar in the acknowledgements for talking to him, and that scholar's face was blackened with black paint by an angry mob in Pune. A mob also attacked the Bhandarkar Oriental Research Institute, a famous research institute, and destroyed 18,000 rare books and 30,000 rare manuscripts only because James Lane had carried out his research in that library. All these books were destroyed. An FIR was registered against the appellant, Manzar Sayyad Khan, and the author, James Lane, under sections 153, 153A, and 34 of the IPC. This was a classic case of a heckler's veto, where an angry mob in Pune got to decide what the entire country could and could not read in terms of the book published by Oxford University Press. The Supreme Court said in this case that the intention to cause disorder, as I told you from Bilal Kalu's case onwards, that is the test. The intention to cause disorder is the sine qua non of the offense. But the intention must be judged by the language of the book itself and the circumstances in which the book was written and published. The Supreme Court said that the matter complained of under section 153A must be read as a whole. One cannot rely on a strongly worded and isolated passage here and there in order to prove the charge. The court said, and this for me was a fascinating part of the judgment. The court said, look at the acknowledgements. Every book, every scholarly book typically has an acknowledgement section. The court said, look at the acknowledgements. The author has thanked his own mother. The author has, in fact, dedicated the work to his mother, Mary Whitwell Lane. And if it was anything but a scholarly pursuit, the scholar would not have dedicated the book to his mother. The scholar has thanked the Bhandarkar Institute. He's thanked so many scholars. This reveals that this is a serious work of scholarship, and it's not really meant to. The intention was not to cause disharmony and hatred among different religious groups. So for any of you who are interested in writing a book that might tend to be on a controversial subject in history, and by and large history and revisionist history in India always tends to be controversial, I would encourage you to write an extensive acknowledgement section and to dedicate the book to a loved one. Not necessarily only as a strategy. I'm sure that you would anyway dedicate the book to a loved one, but that will certainly be taken into account in judging whether you had an intent to cause disharmony or hatred among different religious groups. I think it may be time for me now to wrap up my discussion of the cases. Let me briefly talk a little bit, as Justice Mittal said, about why I decided to study abroad and why after studying abroad and working abroad, I decided to come back to India. So my reason for studying abroad was different from what many people might typically go abroad for. If you think that you should study abroad because it might tangibly and materially benefit you in your day-to-day practice in India, then you're mistaken. Don't go and study abroad if you feel that having an LLM will assist you in your day-to-day practice in India. I went to study abroad because I was interested in academics. I was interested in legal research. I wanted to write books. In fact, I nearly did not come back to India. I had an offer to teach at the London School of Economics. I had an offer to teach at the University of Melbourne, and I almost didn't come back to India. I almost became a full-time academic. Even now, thanks to the lockdown, I'm teaching. Apart from being a practicing advocate, I taught this semester. The lockdown gave me the opportunity to teach a course on affirmative action at Nalsar. Next semester, I'm going to be teaching as an adjunct professor at Cornell Law School. So I was interested in academics, and that's why I went abroad. That's why I did my LLM. I did a second master's, and I did my JSD, my Doctor of the Science of Law. That was my motivation. Now, does that mean that studying abroad does not help you at all in India? Certainly, that can't be right. In fact, there are many cases where I would say that having studied abroad intangibly benefited me. I remember one of my first cases that I argued involving a question of the constitutionality of the Wealth Tax Act. I was arguing that matter against the Additional Solicitor General for India in the Bombay High Court. And there I remember that the principles that I argued, I had drawn on one of the courses that I had taken in the fall semester at Harvard on corporations and mergers and acquisitions. It was because I had studied those principles at Harvard that I was able to apply them in that case that I argued before the Bombay High Court. But that's not necessarily true in every case. So there will certainly be a benefit. Knowledge never goes to waste, as they say. So your knowledge will always hold you in good stead. But really, when you go abroad, you learn more how to think like a lawyer than necessarily only learning the law. Now, why did I decide to come back? I would say the decision was partly personal. I felt that I wanted to be at home. I wanted to be amidst family and friends. I didn't want to be in a foreign country in an alien land. That apart, I feel that the job profile that I have now, the profile of a counsel, does not exist anywhere in the world. Perhaps it exists in the UK, but being a barrister and making it there is quite difficult. It's an old boys club there. Being a counsel in India, I think, is quite a remarkable job because you're not employed by anyone. When I was working for Gibson Dunn, when I was working for Fenwick and West, they were excellent law firms. They gave you a lot of freedom, a lot of independence. I could take my laptop home and work from home. This is much before, several years before the pandemic. Even if somebody called up my telephone in the office, it would ring on my laptop at home. So there was a great deal of freedom. It's not that there wasn't freedom. But at the end of the day, I was employed by a firm. I was an employee. If my boss called me up and said, please come, we need you urgently, I had to get up and go. In fact, I remember so clearly I was once having a lunch with my sister, with my cousin's sister in Singapore. And she had just come from Delhi. She too was interning with a firm in Singapore. And just as we sat down to have our meal, my boss called me up and said, Abhinav, we need you. I said, look, I've just sat down to have lunch with my sister. Can I come after the lunch? And the answer was, no, we actually need you now. So I had to get up and I had to go. And as a counsel, let me tell you, there's no one who can tell me what to do. Not my client, certainly not my client, not my senior, not even a judge. No judge can tell you to get up in the middle of a meal and come. You may decide to do it of your own volition. You may decide that, look, I'll give up my family time and go and meet this judge because the judge has called me. But you're free to say no. You are not employed by anyone. You are only employed by yourself. And so really, in that sense, you are your own judge. That's what I like about this profession. I'm happy to talk about this a little bit more in the questions and answers, but I think maybe it's time for me to wrap up, given that it's now 5:30. So I think let me now open it up to questions. Thank you all so much once again.
Thank you very much, Abhinav. It was a wonderful discussion from you on the basics of hate speech. So I think it is very, very fruitful to all the participants. There are two questions as of now. First question is from Mr. Navraj Rawal. He wants to know the name of Disney Hotstar's show which you talked about. Could you please repeat what is that show?
I believe the name of the show is Hamilton, if I'm not mistaken. Otherwise, just Google Alexander Hamilton Disney Hotstar, and I'm quite sure that you'll be able to find it. It's a Broadway musical, and it's really lovely. It begins with such a powerful phrase. It has a lot of expletives in it, so I don't think I should utter what that first sentence is. But it's to the tune of, how does an immigrant Scotsman, I've left out some words, grow up to be a hero and a scholar. I'm totally butchering it, but please see that play. For those of you who are interested in the Revolutionary era, it's really quite a fascinating play, Broadway musical. It's quite enjoyable. It brought tears to my eyes, so it's deeply moving. And you don't expect a play like that to move you in that way, but I really enjoyed it. So I thoroughly recommend it for those of you who are interested.
Thank you. Now this question is from Shivrit. He says, what are your views regarding the incidents of contempt of court being reported in our country these days?
Okay, so I've written a book called Republic of Rhetoric, in which I've discussed. In fact, that book was published. Justice Mittal, I was privileged to have Justice Mittal present when the book was released. It was written, if I'm not mistaken, in 2017, and I've discussed there what I think ought to be the law of contempt in the country. And by and large, we get our law of contempt of court in the form of scandalizing the court from the United Kingdom, where it's been abolished. The United States has never had this concept of scandalizing the court. In fact, I believe it was Justice Frankfurter who called it an example of English foolishness to have scandalizing the court. But I think that the law of contempt should be used in a very restricted manner. And I think that we need to adopt the test that I spoke about earlier, the test of shouting fire in a crowded theater. So if somebody merely says something on Twitter, merely criticizes the court, merely says that the court is aligned with a political party or B political party, or the court is only dispensing justice for the rich and powerful, that according to me is justified criticism. It may be harsh criticism, it may be incorrect criticism, but let that criticism be countered with the truth. Let it be countered with a counter argument. As Justice Brandeis said, the remedy for false speech is more speech and not enforced silence. So don't put a person behind bars for simply criticizing the court, even in harsh and unfair terms. Now, that having been said, there is a brand of advocates that is now coming into being, unfortunately, whose strategy is to browbeat the courts and to make irresponsible allegations against the court in order to obtain orders. So I feel that the law of contempt should be used today, the law of scandalizing the court, only in order to prevent or in order to preserve the day-to-day decorum and dignity of the court. So if some lawyer decides to stand up and browbeat a judge in the middle of the ongoing courtroom, if some advocate or some litigant decides to say yell at the judge, shout slogans in court, throw a shoe at a judge, something of that nature, then yes, I think we need to have the law of scandalizing the court and contempt of court. But for anything else, where the day-to-day dignity of the court and the decorum of the court is not involved, I think we should really think about abolishing scandalizing the court. In England, for example, I believe that the judges of the English courts actually filed defamation suits. So there was a judge by the name of Justice Popplewell who actually sued some news channel and obtained a decree in damages or an injunction against that news channel. And for that reason, the English system has done away with scandalizing the court. I don't think we can apply that same yardstick in India, because you don't want your judges to become litigants. You don't want judges starting to file defamation suits. Firstly, because it takes so long. Secondly, because people will then refuse judgeship, because they'll feel that, look, in order to protect my dignity, I'll then have to become a litigant, file a suit, wait in the queue for 20 years. So there are pros and cons, there are counter arguments as well. But my personal view is that let's adopt the test of shouting fire in a crowded theater. There is nothing wrong in mere discussion and advocacy of a viewpoint, because it can be countered with another viewpoint. So if somebody has merely criticized the court, even in harsh and unfair terms, that should not be considered contempt in the form of scandalizing the court. Another thing I'd also like to say is that there's something in free speech law called the Barbara Streisand effect. Barbara Streisand, as many of you may know, is a famous singer and actress in the US. And apparently there were some photographs of hers that she didn't want some magazine to publish. And so she filed a suit in order to try and seek an injunction restraining that magazine from publishing those photographs. But as a result of the suit that Barbara Streisand filed, more people saw the photographs than would have otherwise seen them. So when you prosecute somebody for an offense, more people come to know about that offense and what is said than would otherwise have come to know about that offense. So if somebody says something that according to you scandalizes the court, if you ignore that person, probably not that many people will hear about what that person has said. But if you don't ignore that person and you initiate action against him or her for contempt of court, the whole country will hear what that person has said. So actually it will have the completely contrary effect. So there are many reasons why I think that the law of contempt of court should be rethought in our country.
Thank you. Now this is a question from Mr. Sandeep Gandotra. He is a judicial officer. He says, in the context of digitally interconnected India, do you think that the time has come to have some reasonable restrictions on electronic media who propagate the so-called hate speeches for days together? And the end result is the contempt petition against few stand-up comedians.
I see, right. So of course I won't talk about any ongoing case, but the question that you ask is a very interesting one, which is what is the responsibility not merely of the individual who is the user, let's take a software like Twitter or Facebook, but what is the responsibility of the platform itself? Now, under our information technology law, companies like Facebook, Twitter, Amazon, Google are considered to be intermediaries. And the principle is that they are not responsible for what is posted on their websites because they are like a bulletin board. Now imagine I have a bulletin board at my office. I'm only giving a space to people to post their comments. Somebody else may come and post a comment on that bulletin board. But that does not mean that it's my point of view. I'm only giving an avenue, a forum for people to express their points of view. However, these intermediaries, Facebook, Twitter, Amazon, have now gone beyond being mere bulletin boards. So for example, on Google, if you look for a search word, you'll find that Google gives you a preferred answer. In fact, there's a very interesting trademark suit that I'm presently arguing in the Bombay High Court, where my client has a grievance that, look, when somebody types the name of my client's trademark, the competitor's trademark is shown, the competitor's product is shown by Google first as a Google search, as an ad. So that's Google. Then Amazon, when you try and buy something on Amazon, Amazon will tell you that they have a preferred product. So they'll say Amazon's choice. Similarly, in the presidential election in the US right now, you may have noticed that Twitter exercised editorial functions and the Republican Party threatened to take away the safe harbors of the intermediaries. So Twitter and Facebook are exercising editorial functions. They are showing you content that is designed to keep you engaged in the platform. So I think at some point in the future, we may have to ask ourselves the question that do these companies still deserve the protection of intermediary, freedom from intermediary liability that they presently do now?
In fact, you have answered this next question, which is from Megha Anand. She had asked, what are your opinions on Twitter and Facebook book policy when it comes to hate speech? So we'll take this next question from Ms. Balajyoti, is also a judicial officer. She says, how far promotion of hate speech through internet is controlled after verdict of Shreya Singhal's case?
So Shreya Singhal's case was a very interesting judgment delivered by the Supreme Court with Justice Nariman writing the judgment. Section 66A of the Information Technology Act was essentially struck down when it said that even if you annoy somebody on Twitter, on social media, that you can be prosecuted under the section. It was overbroad because Article 19(2) of the Constitution does not make annoyance a reasonable restriction to freedom of speech and expression. But that apart, there are still many statutes, or I should say many statutory provisions, especially in the Indian Penal Code, which very much apply to hate speech on the internet and on Twitter. So in fact, I'm presently arguing cases in the Bombay High Court under Section 482 of the Criminal Procedure Code, where I was in fact surprised when I read the FIR. When I read the FIR, I realized the complaint had been filed by a police officer. The police officer in the Mumbai police says that my job is to go through Twitter and Facebook in order to see if there is any objectionable content that is posted online. So there is actually a police officer in the Mumbai police whose job is to go through Twitter and Facebook and these other websites and WhatsApp forwards and so on, and to see if there's anything objectionable that requires an FIR to be registered. So merely because you post something on Twitter or on Facebook, one should not think that that person is completely invisible to the law. And in fact, there's an elaborate machinery in the state, especially when you criticize the state. There is certainly a mechanism which can be used against you. And of course, the question is whether it's justifiable or not, but there is certainly a mechanism that can be used against you.
Thank you. This is a question from Mr. Mohsin Dar. Does the use of internet come within the ambit of Article 19 of the Indian Constitution as a matter of right to deliver speech and express opinion? If yes, then what's your opinion over the prolonged suspension of high-speed internet in Jammu and Kashmir after abrogation of Article 370 of the Constitution?
So that's a very interesting question. I, of course, again hesitate to express any viewpoint on an ongoing case, but I will say this, that under Article 19(2) of the Constitution, the exceptions to free speech are very broad. Public order is an exception to freedom of speech and expression. Sovereignty and integrity of India is an exception to freedom of speech and expression. It was brought about as a result of the 16th Amendment in very interesting circumstances. It was enacted, the 16th Amendment was brought about at a time when there was a movement in the South to use the electoral process to advocate secession from India. And it was in that context that the words sovereignty and integrity of India were inserted into Article 19(2), after which, in fact, every judge of the Supreme Court, every member of parliament has to take an oath that that person will uphold the sovereignty and integrity of India. So given how broad the exceptions to the right to freedom of speech and expression are drafted, it could plausibly be argued by the state that, look, if we don't curtail the internet in this place, there may be communications that might undermine the sovereignty and integrity of India or give rise to a breach of the public peace and public order. That having been said as a general proposition, I certainly agree that having access to the internet is necessary for communication, for expression of viewpoints, and is therefore absolutely covered by freedom of speech and expression under Article 19(1)(a) of the Constitution.
Thank you, sir. Now this question is from Mr. Bhavesh Bhushan. It is argued that hate speech diminishes the ability of the target group of that hate speech to respond to that speech, and therefore such speech should be restricted. However, arguing from the autonomy perspective, should hate speech be restricted because it may be argued that it should be left to the audience of that hate speech to decide how to respond to that speech, and therefore the speaker should not be restrained from making that speech.
Right. So, in response to this question, I'd in fact invite your attention to a very interesting book written by Professor Jeremy Waldron. Now, Professor Jeremy Waldron, if I'm not mistaken, was a citizen, or he was born in or came from New Zealand, eventually taught at the University of Oxford, and then eventually went on to teach in one of the US universities, NYU, if I'm not mistaken. And so he has these perspectives from different jurisdictions. He has the US perspective of America being an outlier in terms of hate speech. And he, of course, has the common law perspective, the broader common law perspective of England, New Zealand, and so on. And Jeremy Waldron's book called The Harm in Hate Speech makes a very interesting argument. His argument is that, look, by virtue of hate speech, you reduce the target of hate speech to something that is subhuman. You brandish that entire community, or you brand that entire community as being something that is not human. So as a result of that, you're right to say that you diminish the capacity of that group to respond. So that's the Jeremy Waldron argument, that look, because you are belittling those people, because you are diminishing their humanity, we should prohibit this kind of speech. The Holmesian approach, on the other hand, would be that, look, that speech, the hate speech, let's talk about the speech of Nazis holding a rally in a place where predominantly Holocaust survivors live. That speech can be countered with a counter protest. There can be those either who are of Jewish descent, Holocaust survivors, or others who can counter that speech. And so let this debate take place in the marketplace of ideas. It is not for us to censor one thing and leave another thing free from censorship. Another thing that I'd like to say is that giving the state the power to censor hate speech may lead us down a slippery slope, because then the question that arises in these cases is, what is hate speech? In the US, that's not a question at all, because anything and everything is virtually permitted when it comes to hate speech. But in India, we then run or walk on a very thin line. Where does hate speech end and where does free speech begin? So in that process of definition, a lot of power is given to the state, to the machinery of the state, to police officers, and that power is capable of being abused. By and large, let me also tell you, I'm sorry, this is a slightly longer answer, but our constitutional law jurisprudence, by and large, tends to be very deferential towards the government. We have, of course, a proposition that there is a presumption in favor of the constitutionality of a statute. Now, in the US, when a fundamental right is violated, the burden is reversed. The US Supreme Court typically applies a test called the strict scrutiny test, as opposed to rational review, rational basis review. In the strict scrutiny test, the US Supreme Court will apply a twofold standard. It'll ask itself, well, is there a compelling state interest that this law is designed to achieve? And has the state used the least restrictive means in order to achieve that objective? So this is the strict scrutiny test, where the burden is on the state to justify the law. In India, the presumption is in favor of the constitutionality of the statute. In India, at the interim stage, a statute will very rarely be stayed. There will very rarely be an interim stay over a statute. And also in India, very strangely, our constitutional law is summary law, which I find so peculiar. In the United States, a constitutional case originates in the district courts. In a civil trial, evidence is led. The state's witnesses are cross-examined, and on the basis of that, the truth emerges, or at least one would hope. And that case, with its full body of evidence, is then carried up in appeal before the circuit courts and the Supreme Court. In India, we file a petition. The state files an affidavit, and we have to accept the word of the state as the gospel truth because it has filed an affidavit. We can't cross-examine the deponent who has deposed on behalf of the state. So the entire law of rich jurisprudence in our country is summary law. There is no evidence in constitutional law, which inherently makes the process pro-state and anti-individual, in my respectful opinion.
Thank you very much. Now, these two questions are fundamentally same. One is from Ms. Balajyoti and another from Mohsin Dar. There has been a lot of online hate speech. So do we need stringent legislation, or we need a code of conduct without government control? So this was a suggestion in an article appearing in volume 9 of the Journal of Indian Law and Society. What are your views on it?
So, as far as hate speech is concerned, I think that we already have quite a large body of law. And I don't think that we need to add to that body of law with a fresh set of laws that are specifically catered to digital content, because we already have these many sections of the IPC that can be used and that are in fact used against speech on digital platforms. Of course, the raging debate now is whether there should be censorship on digital platforms like Netflix and so on, because there has recently been some movement, and I believe a notification was recently issued by the Ministry of Information and Broadcasting saying that digital platforms like Netflix now will be regulated by the Ministry of Information and Broadcasting. No regulations have been enacted to my knowledge, but the fear is that there may